Welcome to Franchising with Fernandez, and today's hot topic is how does the Parliamentary Inquiry into franchising affect me? On Thursday the 14th of March, the Parliamentary Committee handed down its findings on their inquiry into the franchising industry in Australia. By way of background, the committee held public hearings around the country, and we understand that there were over 400 submissions, causing this report to be delayed 3 times. The committee was charged with looking at the franchising sector as a whole and to determine if there was any need for change since its last inquiry of 2008. Well, this committee has called for a raft of changes, some 71 recommendations in all. So the question is, how will the findings of the committee's report affect me? So if you are a franchisee, franchisor, employee, or business owner, what does it all mean? So I thought, what better way to demystify the committee's recommendations and try to bring some clarity around the 300-page report? So I invited our franchising expert lawyer to see his insights and see how he thinks the report will be delivered. Please make welcome Joe Lazzara, Principal of LSV Borrello Lawyers. Joe, welcome.
Thanks, Mark.
So Joe, why are we here?
Well, Mark, back in March 2018, it was considered necessary to conduct another investigation into the franchising industry. That came out of a couple of high-profile cases, such as the wage fraud in the 7-Eleven franchise system and in the Domino's system, as well as the retraction of the Caltex system and some dubious practices that flowed from that. Although the code had only been recently reintroduced as of 1st of January 2015, it was still considered necessary to conduct a further review. The inquiry called for submissions from a raft of participants in the franchising industry, and the scope of the inquiry was to look into the effectiveness of the franchising code of conduct and whether any further regulation was required. As you rightly point out, the inquiry received over 400 written submissions, conducted a number of public hearings as well as private interviews. And it heard from franchisees, franchisors, academics, other participants and suppliers to the franchise systems, as well as the ACCC and the ASIC. Some of the submissions introduced by the franchisees set out harrowing instances of abuse within franchise systems, and that's kind of framed the response that we got from the committee. All of this culminated in the report from the Parliamentary Committee that was handed down on the 14th, as you indicated, and the report's over 300 pages long, and some of it's quite detailed, going into the background of why we required this inquiry. One of the main recommendations of the report, however, is that it handed down more than 70 recommendations. However, not all of them are recommendations per se for changes to the law, but rather some of them they were deferred to the franchising task force so they could look into it further and then conduct more detailed investigations as to certain aspects of the law and whether or not and how to address those further recommendations. The media release that accompanied the release of the report indicated, and I can read if I can, that there was a systematic exploitation of some franchisees by a subset of franchisors and a regulatory framework that does not provide adequate protection against such practices. So the report was aimed at stamping that out. What the committee did emphasise in their report, though, is that they understood there were a number of franchisors out there trying to do the right thing, and to make sure that they don't come down too harshly on those franchisors. So therefore, the regulatory burden didn't become too onerous. However, in my view, that's kind of been lost in the translation. Sure. That said, as a whole, the committee's recommendations are aimed at lifting standards in the franchising sector, stamping out abuse and the power imbalance between franchisors and franchisees, and making the franchise sector a much more reputable sector, and no one can really argue against that.
Okay, so let's talk about those recommendations. Now, we don't want to go through each of the 71 recommendations, but if there were, half a dozen or some major ones that you think that could impact the franchising industry, can you just talk to some of those?
Well, Mark, it's really hard to digest and split out what those recommendations might be, because every one of them in their own sense is kind of important to the overall effect. The committee advocated that if the government did review this, that they shouldn't cherry pick certain ideas but look at it as a whole. What they were concerned about was if they did cherry pick, then some of the effectiveness of some of the recommendations they had made would be lost if they didn't introduce them as with others. And so it's going to be a difficult process and transition, I think, from the report and its recommendations into eventual law and practice. However, it will be, as a general comment, much more onerous for franchisors, I think, and there's going to be a much more regulatory burden upon them. I think it's true to say that there will be a bit of a shake-up of the franchise system, and it's also important to note that some of the recommendations within the report itself weren't actual recommendations, as I said, as to changes of the law. However, there was a exhortation, if you like, by the the committee to franchisees to get together and start looking after their own interests. So I'll go through a number of those things, and I'll be as specific and timely as I can. And I've tried to split them up into major areas, and I have used the executive summary provided by the committee as a good guide. So the first thing is important to say is, as I said earlier, they've deferred a number of matters for further investigation to what they call a franchising task force. So what that is an interagency task force headed up by the Treasury, Department of Treasury, Department of Small Jobs, and ACCC as required. ACCC as required to investigate further matters in particular, and then to consider how they should round out some recommendations and follow through with law. So that franchising task force will probably be established sooner rather than later, I would imagine, and it will take some time for them to flow through with their recommendations. There have been some important whistleblower protections that have been imposed in the general law at the moment, and they intend to follow those through and pull them into the franchising sector. So franchisees and employees that have genuine complaints against franchisor systems will be free from intimidation and threats, and that was something that came through in the submissions that were made to the inquiry. Franchisee representation, as I said, the committee was quite critical of the Franchise Council of Australia's role. They believe the Franchise Council of Australia was a peak body and is a peak body. However, its membership based is predominantly franchisor and franchisor advisor based, and they believe that that has slanted the recommendations over the last few inquiries and brought a much more friendly environment for franchisors. That should certainly be the case. Again, that comes out of those harrowing experiences that I've mentioned, with some franchisees complaining they've been so harangued that some of them have lost their houses, their livelihoods, and even threatened suicide. So they have exhorted franchisees to get together, create their own industry groups, their own representation. So when the policies and procedures are put into actual law, it provides a much more balanced view for franchisees. Disclosure and registration was a big key. The emphasis of the report being you can't make an informed decision about entering into a franchise without enough disclosure about the key matters. One of the recommendations that is made is that there is additional information given about not only pre-contractual franchise communications, but during the course of the franchise agreement itself. So they said that there had to be enhancement in that area. So one of the main areas they focused on was more information about earnings information and how that should be put together. What they were considering was that in a franchisee resale situation, whether it's a greenfield, never been a franchise in that territory before, or a franchise that is being acquired from an existing franchisee, that much more information be given, and specifically in relation to the last 2 financial years BAS reports. They considered that, lying to the government on your BAS report was much more uncommon than lying to somebody that's buying your business and can't be as easily manipulated. They were concerned about that. And that will create some issues for franchisors, especially in those greenfield site situations where they've recommended that if they can't give actual earnings information for a particular site, that they give one for a similar site. Much to be seen what that would mean, all right? And also they want to do, and they were critical of non-reliance clauses or disclaimers in earnings information. It's quite common for a franchisor to say, I'm giving you the information that's been provided by a franchisee. I can't suggest whether it's accurate or not. And it doesn't really give enough information for a franchisee's advisors to be able to come up with those cost and future earnings models that are required to take a franchise. So they want the franchisor not to step away from that, but rather step into the fray and say, we've reviewed the information, it's responsible and accurate. So that's going to cause a little bit of a risk factor for most franchisors that will be nervous about standing behind those figures, especially where they didn't create them. They want greater clarity, consistency and accountability with respect to marketing funds. They don't think the new legislation that was passed in January 2015 went far enough. At the moment, for example, there is some more focus on making sure that marketing fund monies are used for legitimate marketing fund purposes. However, you only have to report that at the end of each financial year. What they want to see is you drag that forward and make sure that they report every 3 months. So franchisees can keep much more of a track over where their money is going. There were other ancillary recommendations about what would happen to a marketing fund if the marketing fund was wound up, but not need for today's purposes to go into that. They would also recommend it, and it's something that's been picked up by some advocates within the franchising fraternity for some time, is registration of franchise systems. So that would maintain a public register about who's franchised, not necessarily endorsing whether it's a good franchisor or not. However, requiring franchisors that are legitimately going to franchise their businesses to lodge with the government department that will have to be established for this, more likely than not the ACCC, with a mandate to regulate that. Annually, their standard franchise agreements, their disclosure documents, and potentially any ancillary documents that go with that. And there's a real benefit for that. You can tell if it's a public document with publicly available documents and information that a franchisee, before investing in a particular franchise, might be able to compare more than one franchise system. So as we'll get to later on, it might slow down the process, but make them much more aware of what's out there in the public domain. One of the aspects that may be a little bit more controversial is the passing on of fees to franchisees. The committee has recommended that the franchisor be prohibited from passing on its fees for preparation of the franchise agreement and any of the ancillary documents to franchisees, which has been common practice throughout the franchising industry. And also ask the ACCC to investigate matters where they believe that initial franchise fees have been artificially increased to cover those fees. Transparency and accountability in relation to supply chain issues, third line forcing. What the committee was concerned about was potential price gouging by franchisors in circumstances where the franchisee was bound to obtain product supply from franchisees, and it was an area of consternation for a lot of franchisees. So they're looking at ways, and refer this off to the task force, to consider what else can be done to clarify that issue. Unfair contract terms that were passed back in November 2016, and most franchisors have applied across their franchise agreements. They want to make that much more onerous for a franchisor and to prohibit unfair contract terms applying in franchise agreements themselves. At present, the law changed back in November 2016, and most franchisors reviewed their franchise agreements to ensure that there were no unfair contract terms. But they want to extend that across so it applies to all franchise relationships, regardless of the size of the players in those systems, and also to prohibit them and make them illegal, which would ultimately mean that franchise agreements or those clauses themselves could not be enforced. They want to make the unfair contract terms illegal, and if they are found to be illegal, to make them a civil penalty, which is currently not the case. Unilateral variation of franchise agreements and ancillary documentation such as the operations manual. They want to make sure that you can't do that now without the consent of a majority of franchisees. Now that will be a big concern for franchisors who need to be pretty dynamic in the way their franchise system is created and moving forward, especially in the operations manual. Collective action. They want to make it easier for franchisees to get together and to negotiate, especially around disputes and other terms with franchisors. Franchisors won't traditionally like that because they like to be able to divide and conquer, if you like. And also they want to couple that with more robust arbitration provisions. So at the moment we've got an obligation upon franchisors to undertake mediation, but if the mediation is not successful, the only recourse is to go to court. And they want to interpose an arbitration provision that would allow franchisees and franchisors for that matter to have a binding mediation that could award damages and other rights for compensation, etc. They also thought it was relevant to extend some of the civil penalty provisions across into the franchising arena. So at the moment, the Franchising Code of Conduct has certain key areas that will attract a civil penalty. They want to make all breaches of the Franchising Code available for civil penalty, and also to, at the same time, raise the penalties from their current $63,000 maximum fine to potentially $10 million or so. So this is going to be an area of consternation for a lot of franchisors, because at the moment, getting it wrong can sometimes be factored into the franchising costs. However, that's going to be much less of an option if those civil penalties are dragged across to all provisions and increased fines. They've focused on education and advice for franchisees. One of the recommendations that was put forward by a number of submitters was that there should be compulsory advice taken by franchisees before they can buy a franchise. That's kind of been put on the side by the report, but they did suggest that there could be more transparency around when they took a franchise, and so we can have franchisees not being enamoured with the franchise system, and therefore much earlier in the piece that they get an information statement setting out the pros and cons of franchising. But also on top of that, there is a franchisee manual that's published by the ACCC, giving that to franchisees much earlier in the piece as part of the process. And lastly, there was a recommendation that the retail leasing arrangements in franchises should be looked at more closely. And what they're suggesting, that they refer that matter to the franchising task force so they can consider those complex relationships between landlords, franchisors and franchisees, potentially to give a seat at the table to those franchisees in the negotiations with the landlords to get a fairer deal.
So Joe, let's talk about prospective franchisees now. Do you think this report has the ability to slow down franchise recruitment?
Well, that's an interesting question, Mark, and I think that's got a number of different aspects to it. Firstly, I should say, I think it will actually slow down the growth of franchise systems generally. It might mean that franchisors or prospective franchisors will consider whether franchising is the right model for them. If there's an overlay of additional compliance and additional risk, then the question will have to be, is franchising right for us? I can't help but think at this point in time it's going to slow some of those prospective new franchise systems growing, and also within existing franchise systems stopping their growth because the franchisor wants to do so, not so much for the prospective franchisees. Anecdotally, I can tell you from my own experience, a lot of franchisors have been holding off on making any new innovations within their system or attaching or seeking new franchisees until such time as they could see some clarity around what the report was going to bring. And I think that will continue until the report translates into some sort of positive action. As far as franchisees, well, will that cause them to slow down their process? I think it might. I don't think it will stop them or slow them down at all, but at the moment we have a position where a franchisee decides that they want to go with a particular franchise, it's very difficult to dissuade them once they've set themselves on that path, regardless of what the advisors say. So I think the information that they will get will help them, especially if there is a public register, to consider more closely different types of franchises out there. So it may well get them more informed, which is always a good thing, and let them compare apples with apples, or at least different types of franchise systems and the requirements of their disclosure document and their franchise agreements before they take on a new franchise. So it will necessarily slow that process down, but not once they've decided which franchise they want to go with.
So Joe, where do you think this is headed? Where do we go to from here?
Well, from here, the government now will have to review the recommendations that were made in the report and determine which of those they want to focus on. I think sooner rather than later we will see the establishment of the Franchising Task Force, because of course it has to review certain of those aspects that were put forward by the report as to areas that need further consideration and some sort of suggestion of what may happen. I think that will take a while to come through, and therefore we're not going to see any immediate changes apart from potentially the creation of that task force. Of course then from there what will happen I don't know, but I think franchisors should be taking a close look at this report to consider the types of recommendations that are being made and start reviewing their own franchise agreements, their own policies, and how they conduct their business on a day-to-day basis and liaise with and communicate with their franchisees. I think If you are a franchisor that is committed to best practice, this is the instigation that you need to get going down that path and to continue along that path. There will be regulation and there will be changes, and we have to be ready for it.
Thanks, Joe, but we're going to have to leave it there for now. As you have heard from our guest, the recent Parliamentary Inquiry into franchising has the potential to derail the industry through more regulation and compliance. It is our view that caution should be taken with any of the 71 recommendations that have come out of the report. In an industry that employs almost 230,000 Australians, has a turnover of around $130 billion and represents almost 65% of all shopping centre businesses, there are many stakeholders that need to be considered before any action should be taken. BDA also believes that education is the key and not more regulation. BDA believes industry needs an accredited training foundation that brings about best practice mentality and that the benchmarks are consistent across the board. That is one reason why BDA became an accredited facilitator of the Certified Franchise Executive Program, or CFE, as we believe in education to lift the standard across the whole industry, just like the accounting industry. It's that simple. Also, that there is a high probability that the 71 recommendations will not get any airtime, as there is a federal election looming, as close as 10 weeks from now. We understand that this report may not even make an election platform for debate, so we may have to wait a little while and see. Joe has kindly put together a 2-page summary draft, and that will be contained in our BDA Inquiry into Franchising report for 2019. To get a copy, follow the links below on the screen and we will send you one. And this will contain all the issues in the reports and a summary for your viewing. I'm Mark Fernandez, and this has been Franchising with Fernandez. I'm Mark Fernandez, and this is Franchising with Fernandez.